Okay, so good morning, everyone. Welcome to our virtual class. This is for BAM 6201, Law on Obligations and Contracts. So once again, I am Professor Maria Romana and Daguio, your assigned online learning coordinator for this course. So this week class, we are going to have this lesson, Extinguishment of Obligation, the first topic we got for midterm period. All right, so since we already waited enough for other students to join, so at this point of time, let us start. All right, so once again, welcome and good morning. So can you hear me loud and clear, class? Anyone? Okay, so thank you, Azer, Sophia, for responding. All right, so let us proceed. Okay. So our topic for this week is extinguishment of obligation. Paano ba nawawala, no, yung obligations? Okay? So according to Article 1231, obligations are extinguished by the following. Okay, we have 6. 1, by payment or performance. Second, by the loss of the thing due. Third, by the condonation or remission of the debt. Fourth, by the confusion or merger of the rights of creditor and debtor. Fifth, by compensation. And then sixth, by novation. So other causes of extinguishment of obligations such as annulment, rescission, fulfillment of a resolutory condition, and prescription are governed elsewhere in this code. Right. So, tingnan natin ano ba 'tong 'pag sinabi mong payment or performance, no, etc. So, let's discuss further. Okay, so first, what do we mean by payment? Okay, payment means not only the delivery of money, but also the performance in any manner of an obligation. So normally kasi class, pag naririnig natin yung salitang payment, no, ang una kagad pumapasok sa isip natin ay pera. No? Pag nagbayad ka, pera ang pinag-uusapan. No, hindi lang pera. Okay? It can also be performance in any manner, no? Halimbawa, yung to do or not to do. So that is also payment, no? Form of payment. Yung gumawa ka ng isang bagay o yung hindi ka gumawa ng isang bagay, that is also a form of payment. So again, payment means not only the delivery of money but also the performance in any other manner of an obligation. Okay, let's proceed with condonation. Okay, so it is the gratuitous abandonment by the creditor of his right. So again, what is the right of the creditor? So the right of the creditor is the right to demand, no, the debtor for the performance of the obligation. So kung inabandon niya 'yon, okay, we call that condonation. So halimbawa, pinawalang obligasyon niya na yung debtor, so we call that condonation. Inabandon niya yung kanyang right. Okay, next, confusion or merger. It is the meeting in one person of the qualities of creditor and debtor with respect to the same obligation. So the confusion or merger of the right is a mode of extinguishment of obligation wherein the characters or qualities of creditor and debtor are merged, pinagsama, no? Pinag-isa in the same person. So an obligation is extinguished rather if the debtor also becomes the creditor, since one cannot claim against himself. So this particular meeting class will be devoted on payment per se. Okay? So paano yung payment? No? So succeeding lessons natin will uh, respectively devote on other ways on extinguishment of obligation. But for today, we will be focusing our discussion for payment. But let me briefly discuss the other ways on how to extinguish the obligation. Next is compensation. It is the extinguishment in the concurrent amount of the obligations of those persons who are reciprocally debtors and creditors of each other. So pagbabayad, kung ano man yung halaga na ngayon nung kanilang utang or obligasyon sa isa't isa. Since they are not just debtor or creditor to each other, but halimbawa si A, debtor creditor siya kay B. Si B din, hindi lang siya creditor kay A, debtor din siya kay A. So, kung ano man yung mapag-uusapan nila na magiging bayad nila sa kanya-kanya nilang utang and kanya-kanya nilang claim sa isa't isa, we call that compensation. How about legal compensation? So, takes place by operation of law when all the requisites are present. An act which a court orders to be done, or money which a court orders to lie paid by a person whose acts or omissions have caused no loss or injury to the another, in order that thereby the person damnified may receive equal value for his loss or be made whole in respect of his injury. So kung meron mang nangyari na ikinasugat, ikinapinsala, no, monetary man ito in other form, no, so korte magtatakda, no, operation of law kung ano man yung dapat ibayad ni debtor kay creditor. Okay, because of the injury caused by him. Okay, so next, conventional compensation takes place when the parties agree to compensate their mutual obligation even in the absence of some requisites. So parang modified ito, class. Okay? So kahit pa hindi present ang mga requisites, no, kailangan para mabuo ang fulfillment ng obligation, kung sila mismong parties na yon ay nagkasundo na okay, mutually ini-extinguish na natin ang obligation sa isa't isa kahit wala pang ganito, halimbawa delivery man yan or what, so we call that conventional compensation, parang modified version, class, for as long as there is consent, no, and acceptance for both parties. Last is novation, the replacement of an old contract with a new one. So, clearly stated, class, we have our contract pero papalitan natin ng bago. Okay, ano ba yung dahilan? Okay, bakit natin papalitan? First, no, we need to change the object or principal condition. So, maybe that's one. Kaya kailangan baguhin natin yung contract. So, we call that process of novation. Okay, another, substituting the person of the debtor. So, hindi na siya ngayon yung debtor, ibang tao na. So, we need to have a new contract, and that is novation still. And subrogating a third person in the right of the creditor. Okay, so kumbaga, pinapalitan natin, no? Yung pinapalit natin rather yung third person bilang may karapatan na doon kay creditor. Okay? So may mga pagkakataon kasi na ang isang tao gagawa ng isang bagay and then kung ano man yung karapatan ng tao na inakuan niya ng responsibilidad, malipat na sa kanya. Okay? So we call that novation. So babaguhin natin ang contract. So those are the terms, no, terminologies that you need to know, no, for this discussion. All right, so let's proceed now to Article 1232. So this is section 1. So again, we are for payment or performance class. Doon pa lang tayo sa unang way para ma-extinguish ang obligation. All right, so Article 1232, can you please read? Azer?
Article 1232. Payment means not only the delivery of money but also the performance in any other manner of an obligation.
Proceed, darling.
Ang pagbabayad ay hindi lamang sa pagdadala ng pera kundi din sa pagtupad ng obligasyon sa maayos na pamamaraan sa obligasyon.
Alright. Thank you,
This
Azer.
article
Okay na. Thank you. Okay, so according to Article 1232 class, as I've said earlier, the definition of payment, no, dito nakapaloob, clearly stated sa Article 1232, ano ang ibig sabihin ng payment? So, hindi lang delivery of money, but also the performance, yung paggawa in any manner ng obligation. So, remember class, no, the prestations, no, to give, to do, or not to do. So, hindi lang, ibig sabihin na magbibigay ka ng payment, pera agad, no? Hindi lang po doon. Siyempre, yung pagbabayad sa pera, payment pa din ang tawag doon, pero hindi lang yon. Okay? Pati, kung paano mong pinerform yung prestation doon sa obligation, okay, we call that payment. So, this article manifested that the different ways of payment of an obligation is through delivery of money or performance of obligation in any manner. So payment may consist of not only in the delivery of money but also the giving of a thing other than money, the doing of an act, or doing or not doing rather of an act. So example, if D is obligated to give E a specific car, payment is made by delivering the car. So you see, hindi lang yung halaga ng car ang paraan para magbayad, but also yung pag-deliver ng mismong sasakyan. No? That can also be called as payment. Another, if C is obligated to repair the computer of F, payment is made by performing the service. All right? So, ang prestation involved dito, class, is not to give, but also to do. And to do here, class, prestation is to repair the computer of F. So, you see, ang payment hindi lang laging in the form of money. It can also be in the performance of the prestation. All right? So, those are examples, class, of Article 1232, no? Hindi lang delivery of money but also, no, the performance in any manner. Okay, for a moment. Okay, moving on. Article 1233. Okay, so a debt shall not be understood to have been paid unless the thing or service in which the obligation consists have been completely delivered or rendered, as the case may be. Ang isang utang ay hindi uunawain na bayad, maliban kung ang bagay o serbisyo kung saan ang obligasyon ay ganap ng naihatid o naisagawa sa kung alinman. So, hindi natin iti-take na bayad or fulfilled na ang obligation class, no? Kung hindi kumpletong na-deliver or nagawa ang isang bagay. Okay, can you still remember, class, the alternative obligation? Okay, it's where the creditor gives option to the debtor to choose whether to say, to give or to do, for instance. So, if the debtor choose to give something, no, dapat mabuo niya yon. Okay? The debtor cannot compel the creditor to accept partial performance of that prestation and also partial performance of the other prestation and compel the creditor to accept it as full payment doon sa obligation. No. Just like Article 1233, hindi natin po pwedeng masabi na nakumpleto na yung obligation kung hindi buo ang pag-deliver, paggawa o pagbigay ng mga bagay-bagay. Okay, kailangan buo. So a debt may refer to an obligation to deliver money, to deliver a thing other than money, or to do an act or not to do an act. So it must be on the currency agreed on. Kung pera man ang pinag-uusapan, no, it must be clearly stated what currency. Is it peso? Is it dollar? No? Dinar? Or whatsoever. And in the time and place stipulated. So, you know now the currency, kailan mo ibabayad at saan. So, that would also be clearly stated. The thing delivered or service rendered must be exactly that which the object of the negotiation. So, kung anong pinag-usapan natin, yun talaga dapat ang gawin. So, let's have an example, class. Andre promised to pay 1,500 to Adriel for a guitar. Andre is only giving 1,000 to Adriel. So instead of paying 1,500, no, 1,000 lang ang binibigay ni Andre. So Adriel can refuse to accept the 1,000 pesos because the fulfillment is not complete. So kung anong pinag-usapan, sabi dito, exactly that which was the object of negotiation, which is the 1,500. So the creditor may refuse to accept, no, the 1,000. But there are instances, class, wherein even partial performance, no, of the obligation are accepted by the creditor. So, kung alam naman niya, mamaya madidiscuss din natin, kung alam naman niya na kulang, tapos inaccept naman niya at wala siyang reklamo, then it may be deemed that the obligation is now fulfilled. So, kung wala siyang, hindi siya nag-contest, hindi siya nagprotesta or whatsoever, hindi niya ni-reject, no? So, ipagpapalagay natin, class, na si debtor ay fully complied niya na yung kanyang obligation. That is, remember, kung walang protest or walang rejection. Okay? So, in this example, the creditor can refuse. Okay? Kaya nga can po pwedeng tanggapin, po pwedeng hindi. Nasa creditor yun, class. Pero based on what we have agreed, no, in our negotiation, object of the negotiation, you will be paying me, sabi ni Adriel, ng 1,500, not 1,000. So that is Article 1233. Okay, moving on. Okay, Article 1234. Okay, can you please read, Nika? Nika, you're there? You can unmute. Nika. Okay, balikan kita ha. Kay Shian muna tayo. Class, wala kayong mic? Ayan.
Yes, ma'am.
Ayan, okay. Darling, please read Article 1234.
Article 1234. If the obligation has been substantially performed in good faith, the obligor may recover as thought there had been a strict or complete fulfillment less damage suffered by the obligee.
Continue.
Kapag ang obligasyon ay malapit ng matupad sa magandang loob, ang may obligasyon ay maaaring makakolekta na parang may mahigpit na kumpletong
At
pagtupad.
mahigpit at kompletong
At
pagtupad.
kompletong pagtupad. Ibabawas ang pinsala na natamo ng taong pinag-uukulan ng obligasyon.
Thank you, Shihan. Okay. So, Article 1234 speaks of those performance class na almost patapos na. Pero, may nangyaring hindi naman kasalanan ni debtor, kaya hindi nabuo yung performance. So, magkaganon man class, si debtor ay pwedeng makahingi, makarecover, no? Kung ano man yung na-perform na niya. Okay, so ito yung sinasabi sa Article 1234. So there is substantial compliance, okay? Partial lang, okay? Pero patapos na, okay? In good faith. Maganda naman ang kanyang loob, class. Ibig sabihin, willing naman talaga siya sanang din, no? Buuin yung kanyang performance. It's just that may mga hindi lang sakop ng kanyang control na pangyayari, kaya hindi niya natupad. Okay? To continue, there is substantial compliance by the debtor when, in good faith, he has attempted to perform the contract or prestation, but through excusable neglect or oversight, he failed to make full and complete performance for which the other party may be indemnified. So, pwedeng mag-ask na lang ng damages yung kabilang party, pero hindi ito kasalanan ng class ni debtor. Okay? If there is substantial compliance, the obligor may recover as though there has been complete fulfillment minus the amount of damages suffered by the obligee. So, let's have an example to that. Excuse me. So, let me read. Andre obliged himself to sell 1,000 bags of cement to Adriel for a certain price. So, ano ang kontrata, class? Magbibenta ng semento, bags of cement, si Andre kay Adriel, ilang piraso? 1,000. However, despite diligent effort on his part, ibig sabihin sa part ni Andre, siya kasi ang debtor dito, no? Andre was able to deliver only 950 bags, no, of cement because of the cement shortage. So kahit gustuhin man ni Andre na mag-deliver ng 1,000 bags to Adriel, 950 lang na deliver niya class kasi may shortage ng semento. So Andre wants to comply with his obligation to deliver the entire obligation, but he could not do so for reasons beyond his control. Ano yung reasons behind his control? Yung excusable neglect or event plus shortage ng semento. That's out of Andre's control. So under the law, Andre can recover as though there had been complete delivery less the price of the 50 bags. So, pwede nang singilin class ni Andre yung 950 no, mula kay Adriel. Kasi ang consideration natin dito ay hindi naman niya kasalanan. So, hindi po pwedeng sabihin, class, sabi dito, Adriel cannot require Andre to deliver first the remaining 50 bags as condition to his liability for the price. Hindi po pwedeng sabihin ni Adriel na, babayaran kita kung ma-deliver mo muna yung kulang na 50 bags of cement. No. Okay? Ipagpapalagay kasi natin na na-fulfill na, no? Substantial fulfillment na performance no ni Andre no makakasingil na siya for that 950 bags. So he must pay for the 950 bags, Adriel ito, and enforce his right for damages for failure of Andre to deliver the difference. So, ganito, class. Need niyang bayaran yung 950 bags, pero kung meron siyang damages incurred because of the kakulangan, shortage, or incomplete number of bags ng cement, pwede niya yun singilin. No? Indemnification ang tawag natin doon. Okay? It is incumbent or it is expected upon Andre, however, to explain satisfactorily his failure to make complete delivery. So, halimbawa, class, contractor din naman ito si Adriel at dahil maglalaps na ang kanyang kontrata, mapapenalty siya halimbawa ng may-ari pag hindi niya natapos yung kanyang kontrata, kulang nga yung na-deliver naman sa kanya na semento. So, kung ano man yung magiging damages doon, pwede niyang singilin class kay Andre. And it's for Andre to explain, no, satisfactorily kung ano ang naging circumstances ng event na yun. Right? So, that's our example. So, next, Article 1235. When the obligee accepts the performance, obligee, ibig sabihin class, the creditor, tinanggap niya yung performance, knowing its incompleteness or irregularity, and without expressing any protest or objection, the obligation is deemed fully complied with. So, ito yung nabanggit ko kanina, a while ago, na kung wala namang objection, walang rejection, walang protest on the part of the creditor, kahit alam niya na yung ibinigay sa kanya, yung performance ng debtor ay hindi kumpleto or may mali, okay, wala naman din siyang sinabi, in-accept pa rin niya, then ituturing natin class na complied na yung obligation. Okay, kapag tinanggap ng obligee ang pagganap, samantalang nalalaman nito na ito ay di kumpleto or irregular at nang walang pagpapahayag ng anumang protesta o pagtutol, ang obligasyon ay ituturing na lubos na nasunod. Okay? Note, in case of acceptance, the law considers that the creditor waives his right under the principle of estoppel. Pag merong mga pagkakamali, class, at hindi ka naman nag-object, okay, ipagpapalagay ng batas na winave mo yung karapatan mong mag-object pa in the near future. Okay? So, the whole obligation is extinguished. So, bigyan natin yan mamaya ng example. So, Article 1235 of the New Civil Code speaks of the following requisites. Kailan natin masasabi na meron ng fulfillment ng obligation kahit pa nga irregular or incomplete yung nabigay ni debtor? Okay, so ano mga requisites? Una, the obligee or the creditor knows that the performance is incomplete or irregular. Alam niya, nalalaman niya. Nung pagbigay mo, no, nung pag-perform mo, alam niya na may kulang, may mali. But still, in-accept niya. Note, if payment is incomplete or irregular, the creditor may properly reject it. No, common sense class would suggest that if the performance is incomplete or irregular, it's for you to protest. No, it's for you to object, no, you as the creditor. But if In absence of that, okay, then it will be deemed, no, that the obligation is now fulfilled. Okay, another requisite class, he accepts the performance without expressing any protest or objection. Okay, nalalaman mo na kulang yung binigay sa'yo. Mali ang nabigay sa'yo. Okay, pero tinanggap mo pa rin. Okay, so mere receipt, no, yung pagtanggap, the mere receipt of partial payment is not equivalent to acceptance of performance by the creditor. So, may ibang instance naman, class, na tinanggap pero hindi pa rin na-extinguish ang obligation. Doon sa unang diniscuss natin kanina, hindi siya nag-protest, hindi siya nag-object, ipagpapalagay natin na na-fulfill na yung obligation. Dito sa pangalawa naman, tinanggap nga niya pero malinaw na sinasabi niya pa rin na tatanggapin ko to, kulang ito, but you need to give me the remaining items, kung ano man yan. The remaining amount, halimbawa. So, magkaiba yun, class. Tinanggap niya, una, nawala, na-extinguish ang obligation. Pangalawa, pangalawang circumstance, tinanggap niya, pero hindi niya pinawala yung tao na yun sa obligasyon. Ibig sabihin, the creditor is still waiting for the debtor to give the remaining items, the remaining amount, kung ano man yan, or to perform the remaining prestation. So, form of protest. No particular manner or time required to protest or objection. So, wala naman tayo nare-require, class, kailan ka pwedeng mag-object. But, of course, again, pag bigay pa lang sa'yo, the moment you receive that, no, that's the time na kailangan ibigay mo ang sa loobin mo. Ay, hindi to kompleto. Okay? Kasi, i-assume ni debtor na in-accept mo yun. Lalo na, class, yung mga bagay na halimbawa nasisira or na tawag dito nabubulok o kung ano man 'yan. Hindi mo agad sinabi na may mali, hinintay mo pang mabulok yung bagay na yun bago mo sinabi na ay may mali dito. So paano pa natin mapo-prove, makikita na may mali nga. No? So dapat that very instance na binigay sa iyo, pag accept mo, pag receive mo rather, okay, ay nagsabi ka na, nagprotesta ka na. Alright, so long as the acts of the creditor evince that he or she is not satisfied the debtor's payment or performance, the obligation shall not be deemed extinguished. So kung meron agad pag-object, no, pag-reject, no, so hindi ma-extinguish, class, ang obligation. So sabihin niya, kulang ito. Hindi ko to tatanggapin, kulang ito. O mali ito. Sabi ko kulay ganito, ang binigay mo sa akin ganito. So may objection. So hindi na-extinguish ang obligation. Article 1235 of the New Civil Code, no, has this example, class, for you to better understand. A availed of B's services to stencil the name of his business on 3,000 pieces of rosary for donation using a particular font size. So, merong kinontrata si A na ilagay ang pangalan ng kanyang business sa mga rosaryo. Okay? 3,000 pieces yun plus. At may specific pa siyang font size. Okay? Ganito dapat kalaki. Okay? B, delivers the 3,000 pieces of rosary with a stencil on each but using a different font style. So, iba ang pagkakagawa ni B. But A received the rosaries and distributed them to the donees. So, nung pag-receive ni A, wala naman din siyang sinabi, no? O, teka lang, bakit iba ang font style? Instead, tinanggap niya at dinonate na niya, no? Then, obligation now, class, is extinguished. So, wala nang obligation whatsoever si B kasi the mere receipt of the creditor without objection, without rejection, or whatsoever, no, will deem the obligation fulfilled. Malinaw yun, class, ha? So, A, availed of C services to renovate his house for the purpose of making it soundproof. Another example, class. B, renovated the house, but the soundproofing was not effective. A, texted B that he is not satisfied with the latter's work. Obligation is not fully extinguished. Okay. Nagpagawa, nagpa-renovate ng bahay para soundproof. Kaya lang, hindi naman gumana yung soundproofing nila. Okay, so hindi na satisfy si creditor, hindi niya tinanggap. Okay, so the obligation now is not fully extinguished. Okay, so that is Article 1235. So, question so far, class? May mga tanong ba kayo? Okay, so kung wala, let us continue. Article 1236, the creditor is not bound to accept payment or performance by third person who has no interest in the fulfillment of the obligation unless there is a stipulation to the contrary. Hindi natin mapipilit class si creditor, yung pinagkakautangan natin, na tanggapin ang bayad ng ibang tao, no? In behalf of our bayad kung tayo yung may utang doon. Pwera na lang kung meron tayong stipulation. Okay, meron tayong pinagkasunduan. Whoever pays for another may demand from the debtor what he has paid, except if he paid without the knowledge or against the will of the debtor, he can recover only in so far as the payment has been beneficial to the debtor. So kung ikaw, babayaran mo ang utang ng isang tao, okay, kailangan may knowledge ng tao na yon. Hey, A, okay, ako si C, babayaran ko yung utang mo kay B, okay lang ba? Kung pumayag, then go. Okay, pero kung hindi siya pumayag class, ang pwede lang ma-recover ni C sa'yo, okay, ay kung ano yung naging kapaki-pakinabang sa'yo. Okay? So, hindi siya pwedeng mag-demand ng more than that. Kasi ito lang yung napala mo sa pagbayad niya ng obligasyon mo na yun. So, Article 1237 naman, whoever pays on behalf of the debtor without the knowledge or against the will of the latter cannot compel the creditor to subrogate him in his rights, such as those arising from mortgage, guarantee, or penalty. So kung sino man ang magbabayad ng utang ng ibang tao na wala namang consent, no, or hindi alam or labag sa kagustuhan ng taong may utang, hindi niya pwedeng pilitin si creditor na ilipat sa kanya, subrogate, no? Ilipat sa kanya kung ano yung rights meron si debtor. Halimbawa, class, si A may utang kay B. Okay. Hindi alam ni A na binayaran pala ni C ang utang niya kay B. Okay. Kung ganun, class, na hindi niya alam, hindi po pwedeng hingin ni C kay B na kung ano yung rights meron si A dahil siya na ang nagbayad on behalf of A ay ilipat sa kanya. No. Hindi po pwede. According to Article 1237. Kung sino man ang nagbayad para sa kapakanan ng debtor na walang kaalaman o pahintulot ng debtor ay hindi maaring pwersahin ang creditor na akuin ang kanyang karapatan. Katulad ng sangla, garantiya o parusa. Halimbawa, sa pagsanla, okay, ikaw na lang nagbayad nung nakasanla para sa iyo na yung item na yon, no? Eh hindi naman alam ng may-ari. So hindi po pwede. So whoever pays on behalf of the debtor is entitled to subrogation if the payment is with the consent of the latter. Malilipat lang sa iyo, class, yung rights na meron si debtor kung nagbayad ka na meron siyang alam. Okay? That is under Article 1237, 1302, paragraph 2. If the payment is without the knowledge or against the will of the debtor, the third person cannot compel. Hindi niya pwedeng pilitin the creditor to subrogate him in the latter's accessory rights of mortgage, guarantee, or penalty. Okay. So, there be subrogation if the creditor willingly permits the payer to be subrogated in his rights. So, meron bang paglipat class ng rights, no? Kung pumayag si creditor na si A pumalit ay si C pumalit na lang kay A. Since the provision of Article 1237 is for the benefit of the debtor, the subrogation can only take place with his consent. Hindi consent ni creditor class ang kailangan natin dito para magkaroon ng paglilipat ng rights, no, ni debtor papunta kay third person. Ang kailangan makita natin dito ay yung consent na manggagaling mismo sa may utang kay creditor ay kay debtor. So the third person who without necessity paid under such condition is amply protected by his right to reimbursement. Kung halimbawa, hindi naman din alam ni debtor na binayaran nga ni C ang kanyang utang, ang pwede lang habulin ngayon ni C ay kung ano yung naibayad niya. Pero kung ang pag-uusapan natin ay mapasa kanya yung right ng taong binayaran niya, no, sinalo niya sa utang, ay hindi po pwede. Okay? Ang makiklaim niya lang, class, ay kung ano yung binayad niya. Nothing more, no? With that. Hanggang doon lang. Hindi po pwedeng pilitin ni third person na, ako nagbayad ng utang mo doon sa sanlaan. So, akin na dapat yung yang isinanla mo na yan. No. Sige, bayaran kita kung magkano yung binayad mo nga doon, pero hanggang doon lang. Yun ang nakasaad sa 1237. Alright, so let's have an example class to that. Chris borrowed from Gretchen 1,000 pesos. So parties involved, si Chris ang debtor, ang creditor ay si Gretchen. So Bimbi is the guarantor. Without the knowledge or consent of Chris, Penoy paid Gretchen 1,000. In this case, Penoy can claim reimbursement from Chris for the whole amount, 1,000, in as much as Chris was benefited up to that amount. Okay. Unawain natin ha. Si Chris may utang kay Gretchen. Hindi alam ni Chris na si Penoy, binayaran na pala si Gretchen ng 1,000. Hindi niya alam. Okay? So, pwedeng mag-reimburse class si Penoy kay Chris hanggang 1,000 lang. Kasi yun lang naman din ang napakinabangan ni Chris. If Chris cannot pay Penoy, the latter, si Penoy, cannot proceed against Bimbi. Okay. Kung hindi pa kayang bayaran ni Chris, si Penoy, hindi pwedeng habulin naman ni Penoy si Bimbi, yung guarantor, no? Because having paid without the consent of Chris, Penoy is not entitled to subrogation. Okay? Ibig sabihin, hindi nalipat sa kanya yung karapatan, no, na meron si debtor. Okay. So, but if the payment was with the express or tacit approval of Chris, pero pagpalagay natin, halimbawa, may approval ni Chris, Penoy would be entitled not merely to the full reimbursement of 1,000 pesos, but also to subrogation. Suppose the obligation of Chris is secured by a mortgage of land owned by her. Payment by Penoy without the knowledge or against the will of Chris cannot give Penoy the right to foreclose the mortgage because he has no right to subrogation. Bakit wala siyang right to subrogation class? Kasi hindi naman binigyan ng consent ni Chris si Penoy na magbayad ng kanyang utang. So Penoy can recover only in so far as the payment has been beneficial to Chris. So kung magkano lang yung binayad niya na pinakinabangan din naman ni Chris, hanggang dun lang ang kanyang ma-reimburse or yung kanyang mabawi. Okay. Article 1238. Payment by third person who does not intend to be reimbursed by the debtor is deemed to be a donation, which requires a debtor's consent. But the payment is in any case valid as to creditor who has accepted it. So kung halimbawa may third person class na willing bayaran yung utang mo pero ayaw naman niyang magpa-reimburse sa'yo. So, iti-take natin yun class as donation. So, magiging valid yung payment kung inaccept ni creditor. So, may mga tao talagang walang hinihinging kapalit, no? Pero babayaran yung utang mo. Tawag dito, donation. So, ang bayad na ibinigay ni katlong tao para sa inutang ng isang tao na hindi na inaasahang maibalik ang kabayaran sa kanya ay kinukonsidera na isang donasyon na nangangailangan ng kaalaman ng nagpautang. Kailangan pa rin class ng knowledge, no, ng umutang or ni debtor. Ito ay may bisa kung sakalit tinanggap ito ng nagpautang. So, payment by third person who does not intend to be reimbursed, ayaw na niyang mabalik pa sa kanya kung ano yung naibayad niya. So, Article 1238 embodies the idea that no one should be compelled to accept the generosity of another. So, walang sino man ang pwedeng pilitin na tanggapin, no? Kung ano man yung generosity na ino-offer na ibang tao. No, hindi natin pwedeng pilitin. If the paying third person does not intend to be reimbursed, the payment is deemed a donation, which requires the debtor's consent to be valid. However, if the creditor accepts the payment, it shall be valid as to him and the payer, although the debtor did not give him consent to the donation. Example, Cardo owes Aliana 1,000 pesos. Without the intention of being reimbursed, Nena paid Cardo's obligation. So, Cardo had previously accepted Nena's generosity. Tinanggap naman niya. Okay. So, in this case, Cardo is not liable to Nena and his obligation to Aliana is extinguished. So, nagmagandang loob, nag-offer si Nena, Cardo, ako na lang magbabayad ng utang mo kay Aliana. So, tinanggap naman ni Cardo class, pero hindi liable si Cardo kay Nena kasi, no, ito ay kusang loob, no, donation. Iti-take natin as donation. So, yung obligasyon na meron si Cardo kay Aliana class ay na-extinguish na. Kasi tinanggap naman ni Aliana yung payment ni Nena. But if Cardo did not consent to the donation, hindi siya pumayag sa gusto ni Nena na siya magbayad ng utang ni Cardo kay Aliana, Nena may recover from Cardo since there has been no donation. Pwede ngayon habulin ni Nena ang binayad niya kay Cardo. Although originally, Cardo did not intend to be, or Nena did not intend to be reimbursed. Nevertheless, the obligation of Cardo to Aliana is extinguished because the payment is valid as to Aliana who has accepted it. Okay. So, ang magiging concern na lang siguro dito ay kung ay between Cardo and Nena. Pero yung utang ni Cardo kay Aliana, tapos na yun. Kasi tinanggap naman ni Aliana yung payment ni Nena. Alright? So that is Article 1238. Article 1239. In obligations to give, payment made by one who does not have the free disposal of the thing due and capacity to alienate it shall not be valid without prejudice to the provision of Article 1427 under the title on Natural Obligations. Sa obligasyong magbigay ang kabayaran ng ibinigay ng isang tao na walang kakayahang magpasya sa bagay na dapat ibigay at kakayahang maglipat sa iba ng nasabing bagay ay walang bisa. So kung sino man ang nakipag-transact class, nagbigay, no, na wala sa tamang pag-iisip, halimbawa, wala sa tamang katinuan, no, ito ay hindi valid. So this article deals with obligation to give. Ang pinag-uusapan natin dito ay yung prestation to give. Ang obligasyon mo ay magbigay. The payer must have the free disposal of the thing paid. Otherwise, the payment is not valid. Payer who does not have the capacity to alienate the thing, such as when he is non-composed mentis or not of sound mind, wala sa tamang katinuan, the payment is not valid and it can be annulled unless it is made by minors under Article 1427, which states that money or fungible goods delivered by a minor can no longer be recovered. Hindi na pwedeng bawiin if they have been consumed by the creditor in good faith. Okay, bigyan natin ng halimbawa. Suppose Ernesto, a 40-year-old insane, may sakit sa pag-iisip si Ernesto, transfer the title of his land to Tomas, his creditor, for the satisfaction of his debt. Such transfer clause is not valid, okay? Since the insane has no legal capacity. So yung paglipat, no, sa pangalan ng lupain ni Ernesto papunta kay Tomas, okay? Pinagkakautangan niya ay hindi valid kasi walang legal capacity si Ernesto to do that. Kasi nga insane siya. Hindi sound ang kanyang pag-iisip, hindi maganda, maayos. However, further reading of the law will tell us that not all the transactions of an insane person are invalid. Ganito class, hindi naman din lahat na ng pinasok na transaksyon ng insane person ay invalid na lahat, no. May mga pagkakataon kasi na dumadating din sa punto na bumabalik sila sa tamang katinuan ng kanilang pag-iisip. So kung ano man, no, sabi diyan, transactions done during the lucid intervals are valid. Kung ano man yung tinransact niya na nasa tamang pag-iisip siya, no, in between, no? Ngayon, okay yung isip niya, mamaya hindi na naman, bukas or ano, ganyan. So kung ano yung nasa tamang katinuan siya, class, na pinasok niya, ituturing natin yun na valid. Basta yung transaction na during ng kanyang pagiging insane, no, hindi sound ng kanyang mind, no, ay ituturing naman natin na invalid. At saka dapat, no, si Tomas, good faith din siya sa pag-accept, di ba, ng payment. Naalala niyo yung discussion natin last week na sino man tao na tumanggap ng bayad in bad faith shall be liable for legal damages. Okay? Kasi in the first place, alam mo na insane yung tao. Pumayag ka naman na mailipat sa'yo. Halimbawa, sobra-sobra naman kabayaran sa utang ni Ernesto yung ibinigay niya kay Tomas, pero ikaw inaccept mo. So, ikaw na creditor, bad faith ka, so mananagot ka for that. Next, Article 1240. Payment shall be made to the person in whose favor the obligation has been constituted, or his successor in interest, or any person authorized to receive it. So kanino ba natin ibibigay class ang payment, ang bayad? Hindi lang pera, kundi pati yung performance. Pwedeng doon mismo sa creditor, pwede din sa kanyang successor, no? Kanyang mga tagapagmana, or person authorized to receive it, sa kanyang authorized representative. So to whom payment must be made? Again, to the person in whose favor the obligation has been constituted, or the creditor. B, to the successor in interest, like the heirs or any person authorized to receive it. So you can read this case class, Arcake versus Lizares and Company. So facts, D owed C. Si D may utang kay C. Instead of paying C, D deposited the money in a bank in the name and for the credit of C. All this were not done, no, without C's permission. Or all this were done rather without C's permission. So ganito, may utang si D kay C. Pero instead na ibigay yung pera mismo kay C, dineposit na lang ni D sa bangko sa pangalan ni C. Okay. Pero hindi alam ito class ni C. So, ang tanong, has the debt been extinguished? Nawala na ba yung utang ni D kay C? Dahil naibigay naman niya class sa bangko. Okay, hindi nga niya lang na naibigay personally kay C, kung yun ang usapan nila. Okay, na-deposit ko naman eh. Okay, so ito ang verdict dyan. No, the debt is not extinguished class. But if, after efforts had been made, the creditor could not be found, particularly at the place where payment is supposed to be made, the debtor cannot be held guilty of default. Dito sa unang halimbawa natin, hindi naman pinayagan o hindi alam ni C na i-deposit na lang ni D ang pera sa bangko. Nag-intay halimbawa si C doon sa pinag-usapan nila na lugar, no? Pinag-usapan na time, pero hindi dumating si D. Nagkusa siyang i-deposit na lang without the knowledge of C. So, hindi na-extinguish ang obligation. Pero kung halimbawa naman, pumunta doon si D, naghintay kay C, hindi dumating, no? Tinawagan niya, wala pa din. Hawak-hawak niya yung pera, halimbawa, malaking amount. Kaysa sa mawala yun, okay, willing naman talaga siyang ibayad yun, no? Ma-fulfill yung obligation niya kay C. So, ang ginawa na lang niya, dahil alam naman niya yung bangko ni C, nagpunta na lang siya doon para i-deposit. Okay? So, good faith doon si D class. So, hindi siya pwedeng maging guilty of default. Ibig sabihin, hindi natin siya pwedeng sisihin na, hindi na-extinguish yung obligation mo kasi ang usapan, ibayad mo ng personal, hindi mo naman na-ibayad, dineposit mo. After efforts, no, hindi nga dumating si C. So, ang ginawa niya, good faith, no, dineposit na lang niya. Okay, so, pwedeng ma-extinguish ang obligation pagka ganun. So, Article 1241, payment to a person who is incapacitated to administer his property shall be valid if he has kept the thing delivered or insofar as the payment has been beneficial to him. Halimbawa, walang kakayanan para i-administer, no, nung tao na yun, yung property niya, okay? Yung binayad mo sa kanya, no? Magiging valid lang yun, class. Dapat talaga hindi kasi incapacitated nga eh. Pero ituturing natin na valid yung pagbayad mo na yun, yung payment mo na yun, kung napanatili niya yung ibinayad mo, nasa kanya pa din, and naging kapakipakinabang yun sa kanya. So, payment made to the incapacitated creditor. So, what are the effects? If the payment made to the incapacitated creditor who cannot administer his property did not benefit him or he has not kept the thing delivered, the debtor may be compelled by the creditor to pay anew when he regains capacity or by the latter's representative during the time of the incapacity of the creditor. So kung ibinigay mo sa taong incapacitated to administer his property, yung bayad mo ay alam mo naman nga incapacitated at hindi niya napanatili yun sa kanya, okay? So may karapatan si creditor na pagka bumalik na yung kanyang capacity, no, ay singilin ka uli sa panibagong bayad. So, kumbaga, mawawalan ng saysay yung una mong binayad. So, inversely, if the incapacitated creditor has kept the thing delivered or he benefited from the payment he received, the debtor is released from his obligation by virtue of payment. So kung kahit ipagpalagay natin incapacitated nga si creditor pero pinakinabangan naman niya at nasa kanya yung ibinayad mo, okay? So marirelease ka ngayon sa obligation mo. So during the creditor is incapacitated and cannot administer his own property should be given his legal representative. So meron nakatakda ang korte kung sino ang pwede niyang gawing legal representative. If there is none, the debtor may consign the thing in the court. So willing ka naman magbayad, incapacitated yung creditor, ayaw mo namang ibigay kasi baka nga makapagbayad ka uli. So pwede mong i-consign, ibigay na lang, ilapit muna sa court, no? Para yung court ang mag-administer muna nung payment mo. Example, if A owes B, then the obligation matures, suddenly B got involved in a car accident that caused him to suffer coma. So si A may utang kay B, kaya lang, no, nung nag-mature na yung obligation, magbabayad na sana si A, kaya lang, may nangyari naman kay B na coma. So either A can choose to pay B by paying his medical expenses or consign his payment to the court. So mamimili nga yung class si A kung ano yung gagawin niya. O pwedeng bayaran niya pa rin si B, pero kung ano man yung magiging medical expenses niya, na hospital siya, yun na lang ang magiging kabayaran niya. Or yung buong utang niya, i-consign na lang niya sa korte. A's payment will be valid as long as the payment he made will be beneficial to the incapacitated creditor. Alright, so yan lang muna for today class. Okay, let us continue that next